Hello and welcome to the Hunt and Hunt webinar on employment law traps. Just can see some people coming in at the moment, so we'll just give it one more moment to let more people come in. Welcome. If you've got any issues with the recording or the audio, please send through a chat or a Q&A and we'll try and rectify that technical issue. Again, welcome to the Hunt and Hunt webinar. We're talking today about employment law traps and how to keep your business compliant. The purpose of today is to provide businesses with useful information to help manage employees. Employees can be a business's biggest asset and at the same time expose companies to significant risk if the relationship is not properly managed. Again, welcome. I am Sarah Capello and a partner here at Hunt and Hunt Lawyers. I'm presenting with Joey Tass, the associate in my team. Joey and I have been working together for many years and we adopt a very proactive approach when assisting clients manage their employment relationships. Our clients are usually business owners or managers such as HR managers who come to us for guidance and advice. Joey and I enjoy working as a team and believe it is most beneficial to our clients who need employment law advice, which is often time sensitive.
Thanks, Sarah, and hello, everyone. In addition to time-sensitive employment law, and I guess the whole relationship is a constantly evolving one. So we often assist many clients throughout this process from hiring, managing, and unfortunately in circumstances of firing their employees. So the kinds of clients we really enjoy working with are those that we have an ongoing relationship with. The benefit in this is that we get to know the clients and their particular business needs very well. And it allows us to provide the quick, efficient, and cost-effective advice tailored to that specific client. We also like to keep our clients informed on the latest developments in employment law with various articles that we post, as well as webinars, which is what we're here today for.
Thanks, Joe. So today, firstly, we will be breaking up the session into three main categories. First, we're focusing on the commencement and continuation of the relationship and briefly discussing who is the employee. It's actually not quite as simple as you think.
And the second part ultimately looks at circumstances where the employment relationship has ended, as well as disputes that sometimes arise and ways to potentially to try and avoid these.
In the last part, we will talk about current issues that have arisen in the past 12 months, mainly centred around COVID and recent changes to legislation. In this part, we'll answer some common questions. We've also had some submitted prior. Thank you to those who have done so. We'll address those questions today in the presentation.
Lastly, there will be some time at the end for open questions. We will answer as many general questions as time permits. So please submit them through the Q&A function throughout the session. If there's any specific questions, we can take these offline and answer them at another time.
So you'll see at the top or on your Zoom toolbar, there's a Q&A function. You can submit them and then we'll answer them at the end if time permits. So getting into employment law and fair work. The Fair Work Act regulates the employment relationship for most employees within Australia. We're discussing today only the national employment system as it applies to most individuals, but there is a state-based legislation. Fair Work Act and regulations are usually the starting point, although there are a number of other relevant acts, some of which are listed on the site that you're seeing. The most recent, although temporary legislation was enacted during COVID, is commonly called the JobKeeper legislation. Although it has become less relevant to employees as businesses economic recovering, I expect we will see more decisions through the Fair Work Commission relating to this legislation. Not only was it drafted and implemented in a very short amount of time, there was a lot of confusion in its application, and I anticipate that businesses acted either prematurely or without regard to the applicable rules. We're not going to delve into the specifics of JobKeeper today, although reach out if you'd like us to send more resources, as we have previously presented on this topic before.
Okay, so essentially employees can be covered by either an award, an enterprise agreement which may be in place, or in the absence of these, the entitlements come from the National Employment Standards, and you can also have separate employment contracts. So there are in excess of 100 industry or occupation specific awards, which sets out the various obligations required by employers and employees So it is always particularly important for businesses to ensure that they are aware of any specific awards that may apply to them. Because if an award does apply and a business doesn't adopt the minimum entitlements in those awards, then there may be repercussions or potential claims by employees. Alternatively, even employees are able to enter into employment contracts, whether an award exists or not. And even if an award does exist, the main, I guess, thing that employers need to be aware of is the entitlements under any employment contract must be more than the minimum legal entitlements under the award and the national employment standards.
So you really have to understand the nature of the relationship, what the duties are to identify the awards, and then ensure that you're always going to be exceeding that if you're going to adopt an agreement or employment contract. Now, moving to who is an employee, it's not quite a simple question. The most common discussion is around independent contractors versus employees. And there are ultimately a number of factors that can contribute to determining the difference between the two. There's not one indicator, but each case is looked at on its merits and as a whole. And it's important to note that sometimes, even if you have a written agreement that identifies an individual as an independent contractor, the courts can look beyond that and ultimately determine that it's a sham working arrangement. So, and sometimes external agencies can also intervene, such as the Australian Business and Construction Commission, and they can advocate on behalf of the individual to determine that the relationship is other than as otherwise stated. The importance of this is that it can have ramifications for entitlements that are paid. And we'll be talking a little bit later on in the context of casual versus a full-time employee, but note that is relevant also for independent contractors.
Okay, so in this space, Uber has been a big topic of discussion in relation to the identification whether someone is an employee or not. So there was a significant decision back in 2017 in an unfair dismissal case where the Fair Work at that point in time held that the driver utilising the Uber's rideshare application was not an employee within the meaning of the Fair Work Act. In this case, yeah, it determined he wasn't an employee. So there have been, since that case, many other sort of Uber-like cases testing the very nature of the employment relationship, and they've all had pretty similar decisions finding that that specific person was not an employee within the meaning of the Fair Work Act. More recently, however, in December last year, Uber settled one of its high-profile cases involving another unfair dismissal claim by another one of its drivers. My understanding is I think the claim was initiated by the aggrieved driver in the beginning of 2020, and I suspect that they had appealed it throughout. But essentially, in this case, in December, end of last year, Uber had chosen to settle the case before the court was to rule on whether gig economy workers are employees or in fact contractors. The important thing to note in this, although it was a settlement, it does appear on the face of it that Uber had chosen to settle after a line of critical questions were put to Uber's counsel, where even one of the federal court judges had even made off comments saying that it seemed to him that Uber Eats riders appeared to be representatives of Uber Eats. Now, this is important, and because it talks about the I guess overall relationship of the employment relationship, but also if the case didn't settle, it would have been the first time a federal court would have ruled on the status of Uber workers.
And I understand it was reported that after this settlement, Uber changed its terms and conditions to change the nature of the employment relationship to put without question that they actually are independent contractors. So it shows the nature of the evolving relationship between employees and their employers.
Yeah, and I guess the message here is, looking beyond the Uber cases, it's not as simple as labeling someone as a contractor and to determine that's it. You've labeled them as a contractor, so they're a contractor. I guess in this area, it always looks at the legal status of the relationship, and the courts determine this by looking at various factors such as, I guess, the nature of the work, the manner in which it's performed, the control, the image, how tax is paid, how wages are paid, equipment, and also what's the intention of the basis of the relationship. So there are various factors that come into play.
Yeah, so if and when it's determined that somebody is an employee, there are further things to consider that determine the entitlements, such as full-time, part-time, casual, fixed-term contracts, and make sure that you're aware that the legal framework of the relationship is ever evolving. As you mentioned, it's not a set and forget. Employees can start off as casual and then move to part-time or full-time, and you may have to make sure that the contract is constantly updated. Likewise, they might start off as a lower level employee and then move up to have expanded duties and responsibilities. And in those cases, you need protections to be put in place for the business, such as restraints and non-competes, which we'll talk about later. The case of Rosado, which we'll touch upon a little bit later on, was a case where the individual was a casual employee and therefore he received a loading, but the court determined he was full-time and got his entitlements on top. So you need to really be cautious about how these things are actually going to be perceived by the court in due course, which leads to our next slide, ensuring that you're properly documented so that any ambiguity is avoided. So our very strong advice is to always ensure that you have a written employment agreement, even if it's an award employee.
It's imperative to set out the relevant framework, which includes, like I said, the employment agreement, also the position description, defining, I guess, what the roles are within that position, clear terms and conditions of employment. The whole point of doing this for an employer is to minimize the risks and potentially avoid or minimize employment disputes in the future, which can be quite costly.
For most clients, we typically prepare two types of documents, although not for everyone. It's just the general approach that we take. One is for award employees and one is for non-award employees, which are typically managers. These don't need to be over-engineered. They don't need to be lengthy. It just has to be really clear on its terms and relevant to the specific circumstances of each business.
And essentially, like Sarah said, it depends on the certain position, but sometimes in the higher management, it's important to have things like incentive or bonus structures. But you can have them, but it's also important to be clear with identifiable targets in order for it to be utilized effectively. So, one of the things I strongly recommend is for businesses to have in place these policies and procedures in relation to these incentives and bonuses, and also how they're paid, how they're determined, so there's clear expectations. And it's also from a cash flow perspective as well for the business. If they are to determine in future who's going to be eligible for a bonus, then they can manage it that way from their end.
So then we move on to restraints and non-competes or non-solicitations. They're commonly requested in employment contracts, although are notoriously difficult to enforce. Although if they're properly considered and drafted accordingly, then they're a useful tool to protect a business. So they should be contemplated depending upon the factors.
And once again, I don't want to give you the lawyer response, but whether such clauses are enforceable or not is really a case-by-case basis, and it does depend on the circumstances.
As we mentioned, all employment agreements need to be really clear, and so we've got a best practice guide that we've set out into 3 really clear limbs. As I mentioned, the employment contract needs to be clear, but there are 2 additional limbs which are often forgotten about, which are policies and procedures as well as conduct.
Yeah, you're right. Policies and procedures is often forgotten, but in my experience, policies and procedures for an employer are vital as they address the pertinent issues expected of employers, as well as the accepted processes required by employees. It's not just important to have these policies, in my experience, but it's also equally important for employers to communicate them, the policies to their employees, so that the employees understand and adhere to them, as well as enforcing them equally to all. So in my experience, I've helped numerous clients develop and implement policies where they didn't have them in the first place, but they have in turn successfully relied on these policies in defending claims brought against them. So it's very important for businesses to have them.
And this is when they're specific to your business. So obviously we would caution businesses from just going and to the internet and getting policies and cutting and pasting them and saying, here you go, here's what they are. They have to be very appropriate to the circumstances. And this then leads to a case study, which is an unfair dismissal case. There were two cases with very similar circumstances, but the opposite outcomes. And this involved a case where an employee was found to be drinking while they were on work time. Now, in one instance, in both instances, the employee was sacked, and they then brought unfair dismissal claims. In one, it was found that the dismissal was unfair, and the other, it was not unfair, it was upheld. Now, in those cases, one case had a policy and procedure which was followed, and the conduct and the circumstances of the employment were that it was unacceptable to drink at work. In the other, it was not. It was commonly a common occurrence where employees would have a couple of drinks on a work lunch and then come back to the office. Now, in that case, it was deemed to be unfair because although there was essentially a written document saying that you can't do it, it was not adhered to.
Yes, and I had a specific case where for a specific client where one person, for example, slept on the job whilst the other person also slept on the job, and they took action against one but not the other. So there was an argument when I was before the Fair Work Commission about the conduct and applying them equally, and we had to have that argument at the appropriate time.
Yeah.
So yeah, it is very important, as we were just discussing.
This leads to our ending the relationship, which is typically a common question when clients come to us and say, how do I sack somebody?
How do I get rid of them? So look, there are a few ways in which employments can end. I'll just talk about the main ones, which are a resignation, redundancies, and dismissals. Now, first of all, a resignation is a resignation, but particularly in relation to redundancies, it's important to note that a redundancy must be genuine, and sometimes particular processes need to be followed if an employee is governed by an award or an enterprise agreement. And the manner in which an employee is managed and or dismissed goes a very long way in mitigating the risks for employers. So in order to be in the best possible position to defend any claim brought about by an employee, whether you go through the redundancy or the dismissal paths, I always strongly recommend that a process is followed. Employees as well who engage in serious misconduct and I'm here talking in relation to dismissals. You can dismiss for poor performance, or you can dismiss for serious misconduct. If you go down the serious misconduct path, an employer may dismiss instantly, and the Fair Work allows you to not pay the notice period. However, in my experience, I would always tread carefully with this. And before going down this path, I would strongly recommend for legal advice to be obtained prior to any decision being made, as well as the relevant processes to be followed, as in my experience, the consequences for an employer getting it wrong can be more costly.
Yeah. Very, very briefly going to touch upon what can go wrong if there is a dispute. Essentially, it comes down oversimplification of unfair dismissal or an unlawful action claim, which is an adverse action claim. The highest risk is the general protection claim because they're not capped damages. These have to be brought within 21 days. So they're typically time sensitive. What we like to focus on is how you can avoid them. So general protection claims are when adverse action is taken against the employee for a prohibited reason. So this could include discrimination. So for example, somebody is sacked on the basis of their gender, religious beliefs, sexual preferences, or if they make a complaint and they're enforcing a workplace right, then if they're sacked, for example, for wanting to take annual leave, then that is something that is protected. So ensure your managers, employees know and understand general protections, and before you do anything, we can't stress this enough, get the right advice, know the rules before you do so. Now we're going to get to the current issues in employment law and talk about some common questions that are coming up. And in this process, we'll also answer the questions that have been submitted prior. And I know that there's already been a question that's been sent through during this session. So they're very COVID specific questions that we've put that we're commonly getting asked from our clients. And so we've condensed them into more generalized advice, but again, it is really specific to the workplace. So the first one is forcing employees back into the office. So now, the public health policies are saying that it's now safe to allow employees to return to work. So clients are asking, how do we do this? Can I do this? And how does it happen?
Okay, so First question, can I force my employees back into the office, or do I have to approve a request to work from home? So as Sarah touched upon, mid-December last year, the New South Wales government repealed its public health order, which previously allowed employers to allow their employees to work from home where reasonably practical. So currently the way it stands is, in short, employers are able to give a direction to their employees to return to the office. However, employers still have their duties to ensure the health and safety of their workers, whether it's working from home or back in the office, or a mix of both, whatever the case may be. So, however, there are still mechanisms in place under the Fair Work Act, which allows for this notion called flexible working arrangements. And it's in relation to a change of hours or change of patterns of work, as well as a change of the location, and it's relevant here being a working from home sort of arrangement. There are sort of criteria that need to be met. First of all, if you're a permanent employee, you need to have 12 months continuous service or to make the request, or if you're a casual employee that has been employed on a regular and systematic basis of at least 12 months, you also 12 months of service, you also need to tick that box essentially to make a flexible working arrangement request.
So it's important to understand the difference between somebody asking to continue to work from home under previous arrangements, or whether they're formally making a flexible working arrangement. Yes. And if they are doing the latter, then you have to follow a process.
Yes. So there's certain I guess scenarios in which you can make a flexible working arrangement request, and they can be if you're a parent or have the responsibility of care for a child who is of school age or younger, if you're a carer, if you have a disability, if you're over 55 years of age, or there's also circumstances where if you may be experiencing violence from a family member, or providing care and support to another member who's experiencing, I guess, violence in their household. So, but it's important to note that once a flexible working arrangement is made, it needs to be made in writing, and the employer essentially has 21 days to provide their response to that request. Employers may refuse the request, but it's only on reasonable business grounds. Now, I feel in this day and age, there are going to be problems going forward in circumstances where, I guess, COVID-19 forced the issue for working from home arrangements, and in circumstances where businesses have tried it and it has worked, it's going to be hard. I feel like there's going to be disputes in this area when businesses refuse on business grounds.
Yeah, they won't be able to say that it's not reasonable because it has worked before.
Yes, so that's going to be an issue. But my, I guess, advice, both employees and employers, is to, if a flexible working arrangement is made, I guess, is to discuss these arrangements and try and reach an agreement that balances both the needs of the employer and the employee where possible.
Yeah. It's a really good point Joey makes. People often overlook that communication is quite effective. By all means, you need to know the rules and the regulations that govern the employment relationships, but have a conversation because you can get to the bottom of things. We like to help. We don't like to really just head straight to a dispute or to really adopt legalese. It's about making sure that the relationship is ongoing and beneficial to both parties. Now, a really topical conversation that we'll be having is about the COVID vaccination, which I understand one of the vaccinations was approved yesterday, so they'll be rolling them out. I understand. Don't have any specific source information about this, but vaccination is happening imminently. So the question that we get asked often is, can employers require their employees to get the COVID vaccination, and what happens if they refuse? So the answer is, and it's a really annoying lawyer answer, the answer is maybe. And if they refuse, then maybe you can terminate them. So I'm going to go through this in quite a bit of detail and answer the questions that have been submitted. And also importantly, I'm going to provide the manner in which businesses can go about making a mandatory vaccination policy. So just overall and broadly speaking, it'll come down to these factors. Firstly, you have to make a direction that that firstly make a direction that the employees get vaccination, and this direction has to be lawful and reasonable. If the vaccination is necessary to protect the health and safety in the workplace, then you need to consider the specifics of each workplace as to whether it actually is required or not. Then after you've made the direction, taking into account the factor of health and safety, if the employee says no, if they object to the vaccination, what happens then? Can you terminate them? Again, annoyingly, lawyer answer is it depends. But you have to explore what are the reasons they are saying no. So it'll come down, so I'll get to that a little bit later, the reasonings, but then it'll come down as the final limb is taking the vaccination an inherent requirement to continue the employment. Again, it's a matter of looking at the specifics, and we're going to provide some really practical examples of that. The most obvious example when it would likely be determined that it is reasonable and lawful direction and it is an inherent requirement of the position is healthcare workers and aged care workers. In that instance, it's necessary for health and safety and the protection of both the healthcare worker or the aged care worker, as well as everybody else who they're surrounded by. And it's also necessary to fulfill the inherent requirements of the role in order for them to interact with those people. So in that case, it would be likely that the court would uphold a direction if somebody refused and otherwise doesn't have a valid reason to say no. Looking, however, at office workers, for example, which will be more of a grey area. So for taking Joey, for example, who is a lawyer in my team, Joey works from the office, he occasionally works from home. He does interact with clients sometimes, but given COVID, it's sometimes more on Zoom and more remote than it used to be. Now, if I gave him a direction and made a policy that there was a mandatory vaccination requirement, I gave him a direction that he get COVID vaccination, is that a lawful and reasonable direction? If he says no, can I fire him for this reason? Can I fire him?
I hope not.
Well, I'd say on the face of it, it would be no, I can't fire him. But if Joey, however, you have to then look beyond that initial first step. So, for example, if Joey has a client, his main client is in the healthcare and aged care sector, and he has to go to that client to visit them regularly, and therefore he's exposing himself and them to the health and safety risks because he potentially doesn't have the vaccination, then what would happen then in those scenarios?
Well, I mean, key question is attending these client sites an inherent requirement of my job?
That's right. So you'd have to look to see whether there was any alternative arrangements that could be made, or whether something else could happen in order for him to fulfill the requirements, or whether visiting that one client was so necessary for him to fulfill the task, which would make it an inherent requirement.
Well, I mean, I'm just thinking out loud here, but I would just say, can you make accommodations for me? Can I have these meetings via Zoom? Can you go to these clients and make those necessary accommodations? It's just this is what I mean. It depends on what accommodations can be made and whether you can or you can't to determine the next steps that you take.
That's right. Also very relevant is the reason that somebody says no. So why would Joey be saying no? And you have to kind of get to the bottom of that. If there's a very good medical reason that he's saying no, he might be allergic to the vaccination, then absolutely you would not then be taking steps to terminate, unless that is an inherent requirement of the role, which you would go back and ask those questions. If he's saying no just because he doesn't want to, then that might not be good enough. And ultimately, if he refuses the direction, that might be a very solid ground for termination. But you have to look at the specifics. We've had a question submitted about a temp agency and whether a large seasonal workforce, or whether you can enforce a mandatory vaccination requirement then. In that instance, you can't give the lawful and reasonable direction because they're not employees. But what you can do is you can make it a condition of the labour hire agreement, and therefore you need to look at those agreements to ensure that those terms are incorporated. It's likely to be that it's more enforceable because it's a negotiated commercial term than otherwise an employment direction that you're giving. You might also consider policies, and you can have a policy where you refuse entry to anyone onto your work site unless that person is vaccinated. And again, that would be another barrier for allowing that workforce to be entering the site because the policy is in place. Now, the other question we've had is, do we think that work health and safety laws will make vaccination mandatory? I don't know. At this stage, I don't know. Obviously, it's a topic that we are exploring, that we're interested in, we're reading. I understand the Prime Minister said at the last Cabinet meeting that it's not mandatory. He'll make it as mandatory as he can, but it's not. But it might come down to each state. So Victoria recently made it a condition of employment in the aged care sector that employees have certain vaccinations, not COVID, it wasn't released at that time, but they had to have other vaccinations. Otherwise, if they didn't have a good reason, they couldn't work in that area. So it might be very state specific. We just don't know at this stage. I'm not aware of any public health orders just yet. So we'll keep watching this space.
Well, my personal sort of opinion is I think it may be similar to they may try to roll it out and essentially say no jab, no pay if it's in relation to any Centrelink sort of payments, or even if you want to catch a plane somewhere, it may be in their terms of business that you need to have the vaccination to get on a plane and go to another state or country. So we just have to wait and see how it goes.
That's right. Now, if you are a business and you want to implement a mandatory vaccination policy, firstly, you need the policy. So there was a very helpful case that was handed down in 2020 regarding a childcare worker, Arnold and Goodstart.
Yep.
Where they ultimately, an employee was terminated because she refused to get a flu vaccination. Now, in that instance, there was a mandatory vaccination policy that said that any workers had to have the flu shot. And in fact, the employer gave free flu shots. Now, this was in the context, obviously, of childcare, where there's young children around who are not vaccinated and they require protection. So it was, ultimately set out in stone. It was written that it was a requirement of the job. Now, in that case, she was terminated because she didn't. Unfortunately, she lodged the application for unfair dismissal out of time. So the case was rejected on the basis that it was out of time. But in that process, the court considered the merits of the arguments that she would have raised. And so they did touch upon the reasonableness of the direction in the first place. And they found that it would have probably been a lawful and a reasonable direction. Now, this is giving a good indication of what the courts are going to be looking at in terms of the circumstances and whether these are going to be policies that ultimately can be implemented if there's no reasonable objection made. I understand her objection was not on medical grounds or religious beliefs. It was outside of that category, and therefore her termination probably would have been upheld absent the unfair, the out of time. Now, the next really important aspect is having a procedure. You have to set out a procedure for dealing with any objections that are made and considering them on a case-by-case basis. So what happens if a staff member refuses? Consider why they refuse. As I said earlier, in the Arnold case, the objection was not for medical reasons or for healthcare reasons, and she was dismissed. So if that is the case, and there's no valid reason given, or no medical or health-related or religious reasons given, you want to make sure that it's properly documented, and so you follow the process to defend an unfair dismissal case if it comes down to that. If there is a legitimate medical reason, you want to have evidence and support and consider the impact, because then you're going to the inherent requirements of the role. If it's necessary to fill the role, then essentially that's a defence to discrimination, which would be commenced, which would be the action the person would be saying that they're discriminated against on the basis of their medical condition. And the inherent requirements is a defence to that approach. Now, as I said, when it gets to the religious reasons, it's a little bit more grey, but again, have these discussions, seek some evidence, and again, go back to the inherent requirements. So if there's no reason, if otherwise the person just says, I don't want to do it because I don't want to, then it's likely that they are, if the circumstances permit, refusing a reasonable and lawful direction, and then that's grounds for termination. But in that process, you might consider alternative roles that they can do and ensuring that you're meeting a safe working environment.
And I guess the message here is, I mean, it's all well and good if you are an employer and you think you've got all the reasons to dismiss someone for whatever the lawful reason is. But the thing that follows it is sometimes you're embroiled in unfair dismissal or general protection litigation. And it's all well and good to think you're right and make the decisions, but these things then get sort of examined under a microscope in proceedings, and it can be a long drawn-out process and be quite costly. So it's important to get it right from the very beginning, or to consider other alternatives to minimise and avoid, I guess, those disputes.
Yeah. So I've had 2 questions submitted on this topic while we're talking. What are our thoughts on potential government directives relating to COVID vaccinations? We answered that earlier. We just don't know. Watch this space. Do we think employers will be drawn into ensuring employees are vaccinated in order to return to work? Yes, I think they are. Most employers will want to have a safe workplace. They don't want people to be unwell. They don't want to expose anyone to COVID. And if this is going to be a method in order to reduce that, the risk of getting coronavirus, then I think employers would be drawn to that. The same way that often employers encourage people to get flu shots, such as in the case of the Arnold case, where that eliminates the risk of being sick. I think this is something they're going to be looking at. And if it's not done right, then there's a huge exposure. Is it possible for such legislation to be put into place to enforce employers into this type of action? That's a really complicated administrative law type of question. Anything's possible, as we've seen in this COVID day and age, where the government have had immense powers to make directions and have public health orders. I just don't know. I don't think the government will provide legislation specifically on this. They've indicated that they probably won't, but you don't know what's going to happen. Another question we've got is, what about warehouses? Again, it really depends upon the specific circumstances. If it is a warehouse where you can physically distance, socially distance, it meets all of the area rules,
the COVID safe plans.
The COVID safe plans. If there's little interaction, if otherwise you're not dealing with vulnerable people, elderly people, depends upon the nature of the workforce. It really depends. If you're in a regional area versus a metropolitan area, it depends whether it's going to be reasonable to require your staff to get them or not. By all means, implement a policy where it is encouraged, at least, or potentially require it to be mandatory, and then deal with the objection on a case-by-case basis. If people might be willing to have these vaccinations, and therefore great, but it's the ones who are not willing, and potentially there's polls I think I read today where 70% of people indicated they would get it. What about that 30%? Ask them why, and talk through that and go through that process. So you need to look at things really critically and make it a reasonable determination. So then this leads to post-COVID and potential economic impacts. So businesses, as you know, during the lockdown period, there was the JobKeeper legislation that came about, which allowed employees to stand down and react quite quickly, and that you could issue a JobKeeper direction. But a lot of businesses didn't qualify for JobKeeper and now don't qualify for JobKeeper. So what can you do outside of those JobKeeper directions?
So the key question is then, if my business has experienced a downturn, although not enough to qualify for JobKeeper, what do I do? So in these circumstances, if this has happened and you want to put measures in place to ensure the survival of your business, it's very important to ensure that it's done lawfully. Otherwise, the business could potentially be exposed to claims by its employees. So first question, I guess, that comes to my mind is, can you reduce an employee's hours and their remuneration? It's been a commonly sort of explored question, especially since the outbreak of the coronavirus. Now, there are associated risks with reducing an employee's salary, including a breach of contract, potential unfair dismissal claims, or breaches of minimum entitlements under any award or enterprise agreement. If the employee is not covered by an award or an enterprise agreement, they still must be paid at least a national minimum wage. In most circumstances, an employer cannot reduce an employee's remuneration unless it's agreed with by the employee. Doing so without the employee's agreement may result in a breach of contract. There's other concepts as well, such as if you reduce an employee's, I guess, from full-time to part-time, there's the question of, okay, how does their leave accrue? Is it still on a full-time basis? Is it on a part-time basis? On termination, how do you calculate their leave? Is it full-time, part-time? There's all those sort of questions that arise. So you need to be clear in the event you reduce hours or remuneration. Often
people say, why would an employee agree to a pay decrease? And in COVID, people were concerned about losing jobs, so a lot of people did agree to take a pay reduction, which was by agreement. However, there's a case in Queensland, it's actually with a law firm,
I think
against
she
a law firm.
was
She was
a
a
paralegal.
paralegal, and she agreed to a pay reduction. There's no dispute about her agreement, but essentially what she's saying is that she was misled into that agreement because the employer told, it's alleged, the employer told her that everybody else had agreed to a pay reduction and therefore she should. And she did. She subsequently found out that not everybody had agreed, and so she's commencing a misleading and deceptive conduct case. So you have to be really cautious about how you're actually getting that employee to agree to the pay reduction in the first instance.
So I guess a message here is, as an employer, it's worthwhile to have those full and frank discussions with the employee as to the circumstances, because it may be the case that an employee is not inclined to take that reduction, but after you have this full and frank discussion and demonstrate that there's been a downturn in business, in which case the employee may be more agreeable to take that pay cut or the reduction in days once they're aware of the full picture.
If things are so bad though, and you need to look at sending employees down, and this is something that comes up, it came up pre JobKeeper legislation.
Yeah.
People were automatically standing down, particularly during lockdown, and this was a really high risk approach, because ultimately, if you're wrong about this, then you'll have to still pay the employee for that time that they were not otherwise working.
Yeah. So, and this is the thing. Arguably, the stand down provisions in the Fair Work probably didn't think about a pandemic at the time, but it's important to sort of have an understanding of this, and you can essentially stand down an employee if there's a stoppage of work for any cause to which the employer cannot be held responsible. However, there are tests. So first of all, stoppage of work. The Fair Work has pointed out that a stoppage of work should not be so broadly construed to include a mere downturn of business activity, but not so narrowly applied to require the entire stoppage of the business activity. The statutory phrase is a stoppage of work, not a stoppage of the business. And then secondly, a second limb is essentially, can the employee be usefully employed? Now, the Fair Work has also provided guidance on this, on the term usefully employed. And the gist is, if an employer is able to obtain some benefit or value for work that could be performed by the employee, then in the circumstances, the employer would not be able to stand down that certain employee. Now, another option, I guess, in addition to the stand down, sometimes the employer might say, okay, this isn't a too hard basket, and can I make the employee's position redundant? So it's very important to tread carefully in relation to redundancies. It's vital to note that it must be a genuine redundancy. A lot of employers that I deal with don't understand this concept.
I've got a bad employee, I'll just make them redundant.
It's not that simple. So it must be a genuine redundancy, and to establish that it's a genuine redundancy, a process prior to a decision being made must be followed, especially if they're under an award or an enterprise agreement. And the onus essentially falls on the employer to establish that the dismissal of the employee was a genuine redundancy, and they need to show the process that was taken. So, look, I've acted for many in many Fair Work disputes involving redundancies where there has been arguments that the redundancy was not genuine. My number one piece of advice in this regard is for employees to obtain the proper legal advice prior to going and making any definite decision this way or the other way in relation to redundancy, because it must be genuine. And if it's determined that it's not genuine, or the relevant procedure was not undertaken in accordance with any award or enterprise agreement or the like, it will expose the employer to a potential claim, and it will be costly.
Now, moving to managing employees remotely, there's still many employees who are working from home, and how do you manage them? So if they're not sitting in the office, you can't go knock on the door. How do you know what they're doing day to day? Are they watching Netflix? Who knows? So it really comes down to the preparation and the documentation of the employment relationships to see whether they're meeting the expectations or not. So, for example, in their position description or their KPIs, are they properly defined? Is it clear what duties they have, and are there measures to see how they can be properly achieved? So this is coming back to the drafting stage at the start, making sure that it's clearly done. Policies and procedures. This again sets out clearly how the employment relationship is meant to be followed and adhered to. If things are going really terrible and you want to really delve into what your employee is doing day to day, you can monitor your employees' emails. This is permitted, but you must give notice to do so. This is often incorporated into an employment agreement, or there's a policy in place, essentially a surveillance policy. Anything an employee is doing on a business's computer or phone is the employer's property, the business's property, and most employees don't know that. So they often send personal emails back and forth about, my boss is a real horrible person, and this can be viewed by the boss. So just be aware it is permitted, but make sure you have the proper notice in place. If you're getting to the performance management, give warnings, make sure everything is properly documented, file notes, emails, letters, give them the proper counsel. This can happen via Zoom. Provide opportunities for them to rectify. Follow all of the procedures that you required for an ordinary termination. Just do it remotely. But really, the most important part, though, for what we tell our clients is you need to protect your confidential information in your IP as well. And this can be done, again, in the employment agreement or in policies and procedures. And if you suspect that the employee is otherwise operating in another business or retaining some of the IP, then you can take steps really quickly and aggressively in order to protect that. And it really depends upon the level of the employee, but businesses need to ensure that their property and what they've built up over years is protected. So
no, I just want to say, I guess in relation to the last slide, it's been quite clear in our seminar today about, I guess, the Fair Work legislation, how it's constantly evolving in employment law. I mean, the Fair Work Act was enacted in 2009. We're in 2021 now, so it has been tested for many years, and the various cases have, I guess, made those that are making legislation realise there are inadequacies. So, I mean, as of I think it was the last couple of months, a new bill was proposed to make proposed changes to the Fair Work Act, and key areas are, casual employees,
which is a reaction to the Rosado case, which I mentioned earlier.
How do you define them? Is it from the commencement of the employment, or does it get determined throughout the employment? There's wage theft, which is there's been a lot of high-profile cases in relation to underpayment.
Yes. So they're looking at increasing the penalties and criminalising wage theft, which is will be a really big implication, because often, sometimes it is blatant theft, but other times it can essentially be overlooked because you're not reconciling the employee's duties and classifications with what they're getting paid. And this can happen particularly with award employees, as Woolworths and
that's right,
Coles and all that have found recently.
And I guess in relation to that part, they're not looking at basic errors. They're looking at people that systematically abuse the system to underpay their staff. And then there's other concepts in the bill that they're sort of looking to, I guess, amend, and that's offsetting payments, such as the casual. If you're a casual, then you're determined as a permanent, part-time, or full-time, and you've already received, I guess, loadings and things like that. They're sort of, and mind you, this is a proposal in a bill, so it's not law yet, but they're essentially looking at giving the court the power to look at offsetting payments and, payments already made with entitlements that the employee may be eligible for now they're determined permanent employee. And then I guess in this day and age, in light of COVID, they're looking at sort of putting in place flexible work directions, which are similar to the flexible work directions implemented in the various awards today.
Yeah, and just briefly touch the Mondelez case, which was a hot topic for employment lawyers last year. It went from personal leave being calculated as 1 day, which impacted shift workers and part-time employees, but it's reverted back, so everyone can calm down about that. So any questions, and just kind of recapping the points that we've made, we can't emphasize enough: clear contracts of employment, implement policies, think carefully, get advice. But when you do get to a dispute, think commercially. Your business owners, you want to make sure that you're focusing on the core business that you're trying to promote and operate, and think commercially when it comes to this stuff, but get advice and act accordingly.
And also, it's something that you don't really think about much, but if there is a business dispute, I mean, the other thing is there's business interruption. So it puts your time away from focusing on your business to then dealing with this dispute when you can focus. You can put the time to your business. So there are all these sort of unintended consequences as well. So it's important to get it right.
We have a question here. For employees on an employment contract, so non-award employees or who are paid above award, what is considered reasonable overtime? Do you have to pay for all additional time worked beyond ordinary hours or offer time in lieu? Or is it reasonable to expect that some overtime is included in the regular salary? As we talked about earlier, the better off, ultimately they need to be better than if the award was adhered to. So for example, if you have an employee on 120,000 who otherwise would fall within an award category, as long as then they're better off overall than if you apply the award provisions, then ultimately then that would be permitted. So again, it comes down to ordinary answer. It really depends.
And I mean, you can, like for example, you can include in your employment contract, something about overtime hours, or you can say, your remuneration is inclusive of everything. You can structure it in a way, but the main message is it needs to be, I guess, the boot test are better off overall once you compare it to an award.
I've got another question. Does it help to express the possibility of some additional hours in the letter of offer or contract? Yes.
Yeah, so I would, this again, it depends how you phrase it, but ordinarily in employment contracts that I prepare, it says, your hours are from, time to time, from 9 to 5, for example, but you may be required to undertake additional hours to competently, complete the duties of your job. So that's perfectly fine to include. But it has to be reasonable as well. So you can't ordinarily expect your employee to work every Saturday when your hours are, or when your days are Monday to Friday, 9 to 5.
Yeah. So we'll be finishing the questions up here, but any other questions, and Joey and I would love to chat with you about that. Shoot us through an email. We're very accessible. We love talking about this stuff. We live and breathe employment law. So just get in contact with us and we can talk there. Just wanted to give a quick mention of our next webinar, which is happening on the 25th of March. This is on succession planning. It's protecting your family assets plus more. It will be presented by the wonderful partners Joe Dominello and Catherine Keeley from our North Ryde office, as well as Anthea Tronson. So it's definitely one not to be missed. It will be aimed at business owners as well as anybody who have complicated family structures. So it'll be really applicable to anyone who needs to look down that planning path, which is really anyone who's going to die. So thank you very much for attending today. We hope that you got a lot of value out of this. As we said at the start, we really are in the business of trying to keep our clients informed and knowledgeable. We want our clients to succeed. We are here, we provide a resource to clients who we've had for long times. We value our long-standing clients, relationships with clients, and we're here to help. So particularly to see our clients through these really difficult times.
Yeah. So I guess if any employment related questions are, feel free to get in touch and we're happy to assist where required. Yeah, so we'll be sending around tomorrow a recording of this webinar so you can watch it again in your own time, Friday night with some popcorn, or you can if you want to watch it on a Friday night, go for it.
As well as the slides. But thanks very much for joining and we hope you have a great day.
Thank you.